And so another question, somewhat related, how are domestic investments determined to be significant or substantial for the economic prong? Kathleen, do you want to start with that one there?
Yeah, so the significant or substantial is somewhat of an ambiguous standard. The commission has allowed um, flexibility in the approach of evaluating significance and substantiality. It has very broad discretion and evaluates all the factors on a case by case basis. So even small investments for a very large company can be significant. So the ITC tries not to punish large companies who might, on a relative scale, make smaller investments in the US, but in absolute terms, still make huge investments in the US. And that significance and substantiality also has to be both qualitative and quantitative. It can't just be qualitative. So there has to be some kind of quantitative measure of significance or substantiality. Typically, you would look at comparisons between foreign and domestic activities. You might look at the value added to the domestic industry products by the activities in the United States. Is that a significant percentage of the activities that are happening on those products in total? So there's lots of different ways to evaluate significance. You could even compare the investments to the sales of the product in the sense of what does it take to make a sale of this product? What kind of investment in the United States? And the key question is, how important is the U.S. to the patent practicing products?
Excellent. And Joanne, I have a question coming in for you, but I wanted to see if you had additional thoughts on Kathleen's remarks.
No, I think Kathleen covered that wonderfully.
Great. So a question for Joanne, and again, Kathleen, feel free to share your thoughts after this also, but are you aware of any instances of attorneys successfully arguing that the Mentor Graphics case suggests that lost profits need to be apportioned to a feature level?
No, I'm not aware of that being successful to date, but it keeps being tried. I was just at a trial last year where after the presentation of lost profits damages to the jury, opposing counsel tried to exclude the expert opinion because of this very issue. And in fact, two of the cases I had listed on slide 28, CardioNet v. Scott Care and Kennel v. Cooper Lighting, these are more recent examples of attorneys trying to argue that the Mentor Graphics case requires this further apportionment. And very importantly, these two cases have the wonderful rebuttal arguments as to why this type of apportionment is inconsistent with the case law, much of which is the case law that we talked about in today's presentation. But just because it hasn't been successful to date, I do think attorneys are going to keep trying, which is why it's very important to have these notable cases top of mind when you're conducting your lost profit analysis to make sure you are staying within the bounds of the law.